welcome back to another episode of America's Future Law Matters. Each episode, we discuss important legal matters, America's judicial system, and current court cases that America's Future has filed an amicus brief, or at least one amicus brief, in order to shed light on the consequential impact of the case. My name is Alicia Kutzer, and I'm here today with attorney Bill Olson. Hey, Bill.
Hey, Alicia.
How are you?
Ready to go.
Ready to go. That's what I like to hear. So Bill, for anyone that doesn't know us, Bill has been a practicing constitutional and appellate advocacy attorney for decades, and his understanding of our nation's foundational texts is unmatched. We're always so lucky to have him.
Next month, it'll be 50 years.
Really?
Yeah.
Congratulations.
Thank you.
How are you celebrating?
Going to a 50th anniversary of my law school class.
No way, really? Wow. Are you excited to see everybody?
I don't think I'll recognize them. I've stayed the same, but I think many of them look older.
And with that, we'll start our discussion. The case is currently before the Supreme Court of the United States, and the case is Mark Wayne Mullin as Department of Homeland Security Secretary versus Doe. I think it's Delia Doe. So this case was consolidated with another case because both cases have similar issues, so similar facts and issues, and so the court often will consolidate the cases in order to save time and for efficiency. They'll consolidate them with respect to the oral arguments and the briefing schedule, and then they usually, or I tend to notice that they issue one decision with the judgment at the end of the decision for each, with a judgment for each, or they can issue two decisions, even though they've consolidated the case for briefing purposes. So, Bill, the question the Supreme Court is going to resolve in Mullin v. Doe is whether the federal district court erred when it issued an order blocking DHS from implementing a program called the Temporary Protected Status Program in their own way. So the Temporary Protected Status Program is an ongoing program that we've had in our country. And when the new administration, when Trump 47 came into office, that administration decided to continue implementation of the program, but in their own way. And suddenly the courts are up in arms. Did I get that right? Sort of a summary?
Yeah, this came about in the 1990 Immigration Act, the TPS program. It was totally benevolent purposes. It was a very strict criteria as to who could benefit, but it gave the Secretary of Homeland Security the authority to designate certain immigrants from certain persons from certain countries to have temporary, keyword temporary, protected status if one of three criteria were met. And as usual with Democratic administrations, they just ignore the criteria and take the word temporary protected status and give it to anybody they want. But it had to meet one of these three criteria. It had to be an ongoing armed conflict where it would be unsafe to return, or it had to be some kind of an environmental disaster, or it had to be some kind of extraordinary and temporary condition that would cause the people to be unsafe if they return. So they gave the Homeland Security Secretary the authority to be able to designate a country for temporary protected status, and the people could stay for a while, but only for 18 months. Even though they could renew it, it would only last 18 months. The problem is that Obama put it into effect, and when Trump tried for certain countries, and when Trump tried to end that because the crisis no longer existed and the basis for TPS status no longer applied, the court said, well, not so fast. We want to think about this. And then they dragged it out until President Trump left office, Trump 45 out of office. So in comes Obama. What's the first thing he does? Biden comes into office, and what does he do? He revokes what Trump did and says they can stay. So we go through 4 years of more temporary protected status. And then the President Trump 47 comes in and he says, let's try that again. They had extended it 18 months just at the end of the Biden administration so that it would go as long as possible. But Kristi Noem, the secretary, revoked the designation for Haiti and for Syria, I guess it is. And the funny thing is that the court said, how dare you? We want this policy. This was an Obama policy. We stopped you,
Yep.
President Trump, the last time. Biden kept it going, and we're going to stop you again. So the old saying Ronald Reagan had was, "There's nothing as close on earth to eternal life as a government program," and this is another illustration of that.
Yeah, that's so uh, truer words were never spoken, I guess. So I want to go back for a minute to something you said about the TPS, the rule, the statute provides the secretary of DHS with discretion, right, to determine whether to terminate the status or terminate the status of the countries, or to add new countries so that people from those countries can temporarily be sojourned. We've heard that word a lot lately. Be sojourned in the United States. Um, and so thinking about what that means, complete discretion to the DHS to operate or to act through its agents. What that does essentially is take away judicial review so that the court's decision to sort of step their foot into this area and into these cases, it seems would be, I mean, they don't really have jurisdiction. There's no judicial review. In fact, Congress, when it enacted the statute, stated plain as day, the statute provides no judicial review for any determination that the secretary made. So how did the courts sort of negate that entire, I mean, that is plain as day, written by Congress. You don't have courts, you don't have and you're not entitled to review these. You're not even allowed to review these. How do the courts do it?
Well, they each come up with a new theory, and one is sillier than the last. In this case, the judge was Anna Reyes, I guess is pronounced, who's the first Uruguayan judge, grew up in Uruguay, and then now she's a judge in district court in D.C., and she's the first Hispanic woman and the first LGBT judge and the first this and the first that, and she has had quite a record, including trying to stop the president from keeping transgender persons out of the military. So where it appears she had special expertise, I guess, or interest. So here she says to the president, even though the laws, not really the president, but the secretary, even the law says when the conditions for TPS status end, it must be terminated. And that's what Secretary Noem did. But she says, well, you didn't really think this through. And instead of, so her first comment is, the statute says there's no judicial review with respect to the termination, with respect to the decision. And she says, well, I'm not challenging the decision to terminate the status. I'm challenging the process that led to the decision.
It's always process.
Yeah, it's always the process. So that, which makes no sense at all, because it's one determination. However you get there, it's a determination. If Congress says that the courts have no authority whatsoever with respect to that determination, you can't slice and dice the term determination and make it into a bunch of phases. For example, if you think about it, the determination is actually the publication of the rule in the Federal Register. So maybe she would say everything before that is part of the process that led up to it. And if any part of that we don't like, then we can stop it. Or maybe she could say the process was signing the order, and anything that led up to signing the order can be reviewed. just not the signing of the order. So it's just absurd, I think, respectfully, that that you can make a decision to stop the Secretary of Homeland Security from doing her duty to terminate TPS status when the circumstances no longer apply because you don't like the process which led to the decision?
So they're all over the map. These judges lately, it seems like they're going to get their foot in the door, no matter the reason. It's just the total lack of respect for the rule of law and the consistent um, judicial, sort of activism coming from the bench has been, I mean, it's become such a spectacle, just a complete spectacle. And sometimes you feel like we're living with a banana, and we're living in a banana republic to some extent. And the judicial arm of the judicial branch of our government, the people that make up that branch, they're the ones that we have to be able to count on, right? To be honest, not to or slice and dice up definitions and words to their advantage. But these are the people that we need to count on when push comes to shove, and when it's time to decide whether statutes are constitutional, not constitutional, whether someone's rights have been violated. I mean, if we have judges that are unhinged, just acting, they're acting roughshod, or they're running roughshod over the rule of law, and they're issuing decisions based on the outcome rather than the analysis, we're in a lot of trouble.
Yeah, these judges are not calling balls and strikes. They're
No.
not deciding matters according to law. As a matter of fact, America's Future filed an earlier brief in a TPS case having to do with Venezuela
Mm.
in the Supreme Court. And again, a district judge tried to keep Secretary Noem from with ending TPS status so that the district court issues an injunction. And then the Solicitor General goes to the Supreme Court and says, we're asking you to stay that injunction because it was unlawfully entered. The court had no authority. And what does the Supreme Court do? They say, you're right. We're going to stay that because it is likely that the government will prevail on the merits. So you think if you were a district court judge and the Supreme Court has already said the government's likely to prevail on the merits, what's her position? The government's not likely to prevail on the merits. And I don't have to listen to the Supreme Court because that had to do with a different case, a different jurisdiction. And that was Venezuela. And we're at war we just had war with Venezuela. And if you want to come up with a distinction. You can make a distinction between anything. You can say no precedent applies ever because there's some tiny distinction. The name of the case is different. The agency is different. The state is different. The the plaintiff is old rather than young. You can always find something different, but you have to have some honesty
Yeah,
about
absolutely.
establishing rules of law that are drawn from prior cases to follow them. You can't just make it up as you go.
Yeah, to me, this is a classic. It's an affront to to the foundations of our country, to American jurisprudence, and to the law of the land. I mean, the judges sitting in federal district court, presiding over federal district court, they are aware, or their clerks make them aware, whatever, of these sorts of decisions and the close connection to a decision before them. And if if the if the presiding federal district court judge is going to thumb his or her nose up to the Supreme Court, I mean, we have a systemic breakdown in our judicial system, and it's now obvious. This is exactly the perfect example to show the obvious nature of it. It's
The
like, we're stopping Trump. We don't care. The Supreme Court came down with a ruling. We don't care. They don't. It's just total the will of the people that voted President Trump into office in 2024. They will stomp all over those rights, right?
It might be useful just to mention something we did on page 9 of our brief, because when you think about this, the Congress says somebody's got to make this decision as to which countries have meet the standard of an ongoing armed conflict and violating the safety of people if they return. And someone's got to make that decision. We give that discretion to the Secretary of Homeland Security. We confirm that person into office and then they decide. So if a judge comes along and says, no, I decide, I'm a judge,
I'm right. Yeah.
then think about all the things that that does to undermine our system of government. We say in the brief on page 9, it freezes in place determinations made by presidents no longer in office. Earlier, they froze in the Obama policies in effect during the Trump 45 administration. Now they're freezing the Biden decisions into effect during the Trump 47 administrations. Second, it usurps the authority of the Secretary of Homeland Security, appointed by a duly elected president, to make these determinations. Third, that there's an illegal exercise of authority denied to the courts, expressly denied to the courts by Congress. And lastly, to frustrate the will of the people as manifested in 2 presidential elections. What basically a district judge who enjoins a change in policy because she doesn't like the change in policy or the process by which the policy was reached or how the factors were balanced in just making the decision. What she's doing is negating the effect of a presidential election. It is usurping the right of the people to change the president and thereby change the policies. This is how you create terrible discord in a society, when you cannot count on the courts to be able to stand back and allow the people to have a say over their own government.
Yeah, you're absolutely, you hit the mark as usual. The 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 role of the judges is to be umpires, to call balls and strikes, to not weigh in, whether through a decision or through any other manner or mode, into the case itself. They shouldn't be the story, right? The story is the case and the ruling. It shouldn't be about whether or not they've usurped the executive branch's authority, or whether or not they like President Trump or don't like President Obama or whatever president that we're talking about. That shouldn't be the story. Recently, in the last 10 years anyway, that's the story.
And actually, it even went further in this case in a couple of respects. One was, under the Administrative Procedure Act, the court has no authority if the matter is vested in the discretion of the secretary. And the court said, well, that's not going to stop me. That exception doesn't apply. And then there's an equal protection charge where they say that Secretary Nome is racially bigoted and prejudged the matter. And here, so you've got this Uruguayan woman comes in, and maybe there's a difference in how societies operate, but over here we have a good behavior standard for judges. We often say, and you know this well, we've talked about this, that you can impeach a judge and remove the judge, and there's certain standards for that. But beyond that, federal judges have a good behavior standard. And we thought this case was so egregious, we put a footnote into the brief talking about a 1903 case where Congress impeached Judge John Pickering for for just disregarding statutes in deciding cases. Now, he was also a habitual drunkard, and there were a few other problems, but this is fascinating because Congress doesn't want to come up with a system to be able to give effect to the good behavior standard. But these judges, they don't only serve um, as long as they don't commit an impeachable offense, but these are historically are proven to be impeachable offense if they just disregard a statute and rule the way they want to rule.
Yeah. Well,
And in this case, imputing to the Secretary of Homeland Security a racist, biased, prejudicial view And
Hmm.
maybe this case annoyed us more than most, but we also we also said, to the judiciary, maybe you ought to think about how this can be used against you. If you're going to say that anytime the president or the secretary of Homeland Security makes a decision you don't like, it's racist, and we see bias in you, well, maybe the president's going to say, I read your decision, court, but I think you're biased. And so we're not going to follow it. So this takes us down a very
Hmm.
difficult
Dangerous.
path here. But if the judge can impute bias to Secretary Noam, why can't the president impute bias to the judge? It's a dangerous thing they're doing. They've got to stop it before it does systemic damage to our country. I don't know how they do things in Uruguay, but that's not the way we do things here.
It's a good point. It's that would, I mean, the irrevocable, or I guess the irreversible harms to society when this is the path it chooses is I mean, undeniable, I guess. It's a real shame. From a legal perspective, the judge to for a judge to look behind a facially appropriate and proper purpose with respect to what the government does or doesn't do is a scary, without any, especially without any sort of evidence of it, but to look behind a perfectly reasonable purpose for implementing whatever statute we want to talk about, that's that gives way too much discretion, way too much power to a person presiding over a case. I mean, if you're presiding over a case, you should have there's an oath. You should abide by your oath of impartiality 100%. And when you're looking behind a reasonable purpose for the government doing whatever it's doing, we got a problem.
The TPS status, where you have this kind of extraordinary ongoing armed conflict, is almost always in a country that has a non-white population. They went through and listed all we put in the brief, all the cases where there are TPS status. Afghanistan, Burma, Myanmar, Cameroon, El Salvador, Ethiopia, Hawaii,
You
Honduras,
forget
on and on.
the courts don't care about facts.
Well, we put it because if you're going to say revoking TPS status indicates you're a racist because the people who are benefiting from the status are not white, well, all of them are not. But the only country that has the designation that's a white country, I guess you'd say, is the Ukraine.
Mm.
So basically, once you put it into
Yeah.
effect, are you a racist by saying that no longer is there an ongoing armed conflict that puts someone into a position of unsafeness? That is it possible that you can change the temporary protected status for somebody due to an environmental disaster like the 2010 Haitian flooding and such that occurred down there? I forgot exactly what that was.
A hurricane, I think.
Yeah, hurricane. And
Hmm.
does that ever end? And if it ends, does that make you a racist? So this is part of the society problem in the society at large. Just imputing malice to political opponents, and in this case, to legal litigants.
If I'm understanding you, what you're talking about is there couldn't have been. Let's take Ukraine out of the story. It's one out of many many countries that TPS status is, or the TPS program is affected. So we take Ukraine out there, and we'll put them back in in a minute. But there couldn't there's this couldn't be discrimination on the part of the government, because when you're looking for sort of especially disparate treatment, but you're looking for discrimination, there has to be some sort of basis or comparison. And if every country looks the same, the demographic looks the same, well, then how can someone show the Secretary of Homeland Security is discriminating against one country uh, demographic versus another country's population? So essentially, the proof for racial discrimination, they can't even form any basis of it.
It,
basis to it.
the equal protection notion doesn't apply in the
Right.
immigration world. I mean, if it does, it's tiny, but it certainly doesn't apply in a situation like this. As a matter of fact, it's interesting. People who aren't lawyers who might listen, they might find it interesting that there's an equal protection clause in the 14th Amendment, which applies to the states, but there's no equal protection clause in the Constitution as applies to the federal government. However, because the Supreme Court struck down discrimination in public schools and Brown v. Board, it felt obligated to come up with what they call the equal protection component of the Fifth Amendment and find
Yeah.
it buried in the due process clause of the Fifth Amendment.
Mhm.
And thereby, and now this is but they said, well, we're going to find it there because we'd be embarrassed to say that states cannot discriminate in their schools based on race, but the DC government, which is part of the federal government, can. So they had
Yeah.
to come up with a phony doctrine. And it's actually atextual because due process obviously doesn't include equal protection because in the 14th Amendment, there's a due process clause and an equal
Equal
protection
protection.
clause.
Yeah.
So here they say, well, it's part of due process in the Fifth Amendment. No, it isn't. Nobody ever thought it was. They had to come up with some excuse. So they manufactured an equal protection component of the Fifth Amendment. And now, once you do that, then the judges like this come along and say, oh, the federal government, all of our immigration policies have to be race neutral. We can't discriminate. It These rules don't apply here, and it doesn't fit, and it shouldn't. The D.C. Circuit should have fixed it. The Second Circuit should have fixed it. Now the Supreme Court has to fix it, and I'm quite optimistic because this is very much an outlier decision.
Yeah. I agree, and we've already seen the Supreme Court uh, cure some of these types of defects. So I know that America's Future filed this brief bill on March 30th of 2026, and the Supreme Court, which has already accepted the case for review, scheduled oral arguments for April 29th. And so,
And it's
um,
all expedited. Yeah.
well,
And by the way, just 2 days ago, a district court in Massachusetts, the same one that enjoins
right.
President Trump every other day, enjoined President Trump from revoking TPS status for Ethiopian.
So
Uh,
here we go again, right?
it- one more kind. So when I said it's an outlier, I guess I should say it's the norm these days, but it's an outlier historically to think that you're going to take doctrines like equal protection and use it to reverse the policy changes in a presidential election.
Sick. It's absolutely sickening. I mean, the courts they're using their under the color of law, let's say, using their authority as courts to run politics or run cover for whomever. I mean, they're essentially operating as though they're political operatives rather than umpires, weighing facts and issuing decisions that are have legal basis. It's really despicable.
What a district court judge thinks about a TPS decision is not important.
Or about President Trump, right? Because it
Yeah,
continues.
or Secretary Noem.
Hey,
Their
it's
own
a delay.
personal policy views, you can't just put it in an order and call it the rule of law when it's a
Exa-
decision based on policy.
Exactly. Can somebody please take Bill's words and make a stamper right on the head and then stamp the heads of the judges
Well,
that don't seem to understand it?
I hope the Supreme Court fixes this. This has got to be fixed.
Yeah, we'll know soon. We'll know pretty soon. This has got to be fixed. This would allowing this to stand. It undermines the rule of law once again, and the Supreme Court has done. I've seen a pretty good, even though there are some decisions I disagree with. At least I've seen a pretty good move towards protecting the rule of law. Do you agree with that, or do you think they've gone off the reservation?
I don't, we've now done what 35 of these shows or something, and this is and
More than that.
usually we're trying to be pretty judicious about
Hmm.
recognizing that even people we disagree with have theories that
Yeah,
have bases for them. This is very much the exception. This is a very unusual case, and it's very hard to take the rationale advanced by the district court seriously, and it's so sad that the DC Circuit just let it fly. The Second Circuit scarcely issued an opinion, just affirmed.
I know something there. I mean, who's pulling those strings? Because something's wrong. It could be that they're doing these things without any consequences. There's no accountability. The judges do whatever they want, and then make if they rule like this, that's against the rule of law or against statute, against the Constitution, oh, then what happens to them? Nothing. Their ruling may be overturned, maybe vacated or reversed, and that will cure the defect in their decision, but absolutely nothing. They get away with it. They can do whatever they want. There's just no limitations.
And what's just to add one final thing,
Yeah.
what's worse is that how long it takes to fix this.
Yep,
Here we had
exactly.
Secretary Noem took away TPS status for Venezuela. Supreme Court immediately stayed it. But then all these other judges feel totally at liberty to do it with respect to all the other TPS designations, even just Ethiopia, we just said
Yeah.
in Massachusetts just 2 days ago.
Lack
So,
of consequences, lack of accountability.
and they run out the clock on the president. He's only there 4 years. They're
It's
going to
not
be
fair.
there a lot longer. And as long as they have the power to enjoin the president, they have the power to stifle the implementation of the policies that the people elected the president to implement.
We'll end it there today. That was what a discussion. So thank you, Bill, for all the insight and just some really great examples and thoughts. It's really I appreciate so much our discussions. And I want to thank you guys all out there for taking the time to listen and watch us and for joining us today. It is so important to stay informed, particularly about issues that are going to matter to you or that do matter to you, your family, your community, and of course all of our fellow Americans. If you'd like more information about this case or to read the brief, please visit America's Future Law and Policy page at americasfuture.net. So that does it for today, guys. We will see you soon for another episode of America's Future Law Matters.